Hello, and welcome to our webinar, Protecting Your Business Team and Assets from Your Competitors. My name is Stephen James. I'm the Dispute Resolution Team at Claes Legal.
And I'm Anita Mishra. I'm one of the employment partners at Claes Legal.
A very quick word to start about Claes Legal. We're a full-service commercial law firm with offices in Reading and where we're broadcasting today in London. We are talking today about restrictive covenants, and before we get into the meat of the webinar, I'll just say a word or two exactly what we mean by restrictive covenants. Typically, there are three main covenants that you find in an employment context, and in their hierarchy of severity, starting at the top, you have non-competition clauses we call non-competes. As the name suggests, this is something that prevents an individual from competing with his ex-employer for a period of time. And in certain circumstances, it may prevent that individual from working at all during the period of the restriction. Going down the order of hierarchy, you have a non-dealing clause, which allows an employee to compete with his old employer, but will be prevented from doing any business with a particular class or list of customers during the period of the restriction. And finally, a non-solicitation clause, where you're allowed to compete and you're allowed to deal with any other party, but you're not allowed to actively go and poach business from your ex-clients or go and poach your ex-colleagues, get them come and join you in your new business. We're dividing today's webinar into 10 top tips. Anita will be starting off with 5 tips in the context of drafting covenants to ensure that they're enforceable, and I'll be dealing with tips 6 to 10 from an enforcement perspective, so how you put these rights into practice.
Excellent, thanks Stephen. So, drafting tips. Before we get into the top 5 tips that I've come up with from my practical experience of the queries I get and the tests of these covenants that we see, I just want to spell out the broad background. The starting point for restrictive covenants, of course, is that they are void for being in restraint of trade and contrary to public policy. Therefore, the courts will only enforce them if they're reasonable. And reasonableness is a recurring topic that will come up throughout the tips that I present. So, looking at the first tip that I have decided to talk about, which is all in relation to what interest that you are protecting or trying to protect as a business. Now, as employers, we can't just impose restrictive covenants because we don't want an ex-employee to compete with us. But what we can do is try to prevent the ex-employees from using something that legitimately belongs to us. So therefore, the first step is to think about what interest are we trying to protect here. Broadly, the interests that are capable of protection via restrictive covenants fall into 3 categories. We've got, firstly, trade connections, and these could be with your customers, clients, or suppliers, or all of the above. And generally, this covers goodwill as well. The second broad area of interest capable of protection are trade secrets and confidential information. And the third is the stability of your workforce. So looking into the detail of this a bit more, you will often see when you're looking at a precedent clause or when you're looking to draft one, that the introductory wording often sets out the interest that as the employer that you're trying to protect. For example, it will acknowledge the interests and state this is why, effectively, that the covenants will follow. So the restrictive covenants that follow that will be interpreted with the introductory wording that sets out the interest that you're trying to protect. And you won't be able at a later stage to rely on non-stated interests within that haven't been captured within the initial contract. So I've highlighted a rather old but really important case in the world of restrictive covenants, which is Office Angels and Rayner, Thomas and O'Connor. In that case, the introductory wording in that in the restrictive covenants clause stated that the employees would have dealings with clients, and therefore to safeguard the goodwill of the employer, the employee agrees to the following. And then thereafter you saw the normal restrictions you would expect to see in the restrictive covenant, and that is 90% of the time the way a restrictive covenant is set out. So a legitimate interest we can see from that wording would be the trade connection with the clients that was expressly acknowledged within the clause. But when this all went horribly wrong and went to court, the employer tried to say, our pool of temporary workers is also a legitimate interest. Now, Office Angels are a employment agency, and therefore their business revolved around having clients who would engage the services of temporary staff members that they would supply to those businesses. So in considering this, the court said, well, yes, actually, that would be a legitimate interest. Your pool of temporary workers, it would have taken you a long time to build that up, and it's a valuable asset. It is an interest that would be capable of protection. But you didn't state it within your restrictive covenant and your contract, and therefore you can't now rely on it. So I think that's a good word of warning practically, that to think about what interests that you are trying to protect with these covenants. Have a think about it, make sure that you decide what they are, and then expressly acknowledge all of them within the covenants. Okay, moving on to tip 2. This is quite a big tip, because reasonableness really is the centre of all of this. And this is really only to draft in reasonable protection. Now, the reason reasonableness is so important is that failure to pitch at the appropriate and reasonable level will result in your covenants being void for having too wide a scope. So really it's a balancing act between the interests of the employer's business on one hand versus the employee's right to freedom of movement and the ability and right to earn a living on the other hand. Moving on to the next slide, the specifics of this I'd wish to flag are that the restriction should be no wider than reasonably necessary to protect the employer's legitimate interest. And therefore, it follows that we need to really tailor the restrictive covenants to make sure that they fit the particular circumstances. Now, ideally, each contract being issued should have its restrictive covenants individually considered as applicable and appropriate for that particular employee. And that's even if employees are at the same level. Because, for example, you might have on one hand an employee who has lots of access to confidential information and one who doesn't, despite being at the same level, and the same in relation to customer contact, etc. The reality is, I know that very rarely employers have the time, resource, etc. to tailor the restrictive covenants for each new person they bring on. So what I would say is at least have a look at the template precedents you have for various job levels or grades and think about realistically what job roles fit within those templates, what would be appropriate and reasonable for them as a minimum. Okay, so I've mentioned tailoring. Well, what exactly do I mean by this? I'll take them in turn in terms of what has to be tailored. So firstly, looking at the restricted activities. So if we take the solicitation or non-solicitation of customers, so it's common ground that these should be limited to those who the departing employee has dealt with within a particular period. And that's because a covenant that says, look, you're restricted from trying to solicit any of our clients who have ever existed within the organisation, that's going to be too wide a scope. That's wider than is reasonably necessary to protect the employer's interests. So tailoring it to customers that individual has had contact with, that kind of brings it back to preventing the exploitation of the advantage that employee would have as a result of having contact with those. If it's widened to all of the clients and customers of the firm, that's going to be too wide. So have a think about the time period going back where that employee has had contact with it and how long you need to take that back. It might be 12 months, it might be 6 months, it depends how quickly contacts and leads, etc. would go stale within your industry. You'll see a case at the bottom of the slide of the Tillman and Egan Zender Limited, and this related to an executive search company. And within that, there was some interesting and useful commentary in relation to restricting activities there. So this involved a 6-month non-compete clause, which prevented the employee, and the wording was, from being concerned or interested in any competing business from 6 months from termination. Now, in being interested in, on a strict reading of the clause, would mean even holding one share in a publicly listed company. So obviously that's very theoretically wide. And the wide nature of that, which was beyond what was necessary to protect Egan Zender's legitimate interests, invalidated the clause so it wasn't enforceable. And I'd say from that, therefore, that the practical takeaway is when you're trying to restrict activities, exclude minor shareholdings, because that's not really going to have an impact on your business, and it could, like it did in this case, render the clause void. The other point to think about in terms of restrictions are the period of restriction that we're talking about. It's one of the most commonly asked questions to me as an employment advisor is, well, how long, Anita, how long can we put these in for? What's the maximum? And it's not necessarily the right way to go about looking at this in terms of just thinking what the maximum that you could get away with would be. But the answer when I'm asked, and I have to give it, is that 12 months is generally regarded to be pushing the boundary as to the maximum that the courts are willing to impose in an employment contract context. I would say questions to ask yourself when deciding on the period of restriction the answers to these will be more telling as to how you set your time period. So think about things such as, well, how long before the influence of the departing employee is lost over the customers that you're trying to restrict? Is there an industry standard would be another question to consider. So, for example, in financial services, 12 months is considered to be the industry norm. Or if you're looking at it from a sales context, well, the question would be, well, how long before we can replace the departing employee and before their replacement can forge relationships with the customers that the ex-employee had? And the answer to that is likely to be the time period that's appropriate to limit the period of restrictions to. Finally, think about whether you need a geographical restriction, so i.e. you cannot compete within X number of miles of a particular place. Now, the geographical restrictions, in my experience, are becoming more rare in terms of their inclusion because quite often the restricted activities are self-limiting, but they can be needed, and you have to think about whether it's really necessary for your business. What I would say as a word of warning is, and referring back to the Office Angels case that I mentioned before, only put them in if you really need them. Don't put them in for the sake of it. In the Office Angels case, they had only a 1 kilometre restriction, which obviously is a very, very small geographical area. But they really analysed it, and the courts really do analyse everything you put in your restrictive covenants if they're ever tested. And they basically, the courts in that one said, well, actually, the evidence here is that your customers don't mind where you're located. It's not relevant. They place their orders over the telephone. And therefore, you don't actually need a geographical restriction. And so even though it was 1 kilometre, it wasn't so much the area, it was the fact it wasn't needed at all. It was wider than necessary to protect their interests. And that also contributed to it rendering the clauses void. Okay, moving on to the third tip. When drafting restrictive covenants, you'll always get to the non-competition section. And I would say really think about using non-competition clauses sparingly. And this is what this tip is centred around. Stephen's, of course, already mentioned the hierarchy of the types of clauses and increasing kind of levels of onerous nature. We've got non-solicitation, as Stephen mentioned, then we've got non-dealing, and then non-compete, and i.e. preventing an employee joining a rival for a particular period. Now, of course, that's the most powerful weapon within an employer's armoury for trying to protect its interests. But because of that, and because it is the most onerous, it's the hardest to enforce. Having said that, it is a useful tool. You should use them when appropriate, and they are used for senior employees regularly, and they are frequently upheld. I would say that the scenarios in which you would want to be thinking about using these non-competition clauses would be when their influence over a customer will be so great that it's the only effective protection that you would have against competition, against you're protecting your interests. Secondly, when it's inevitable that the employee would use the confidential information in a competitive role. Or thirdly, when you would have trouble policing either a non-solicitation or a non-dealing clause. It's in those scenarios that you'd want to think about using your non-compete clause. So, looking at the detail of some of this. Covenants with the sole aim of preventing competition are never upheld. Instead, they should be in place just to prevent the exploitation and unfair advantage that your ex-employee has gained from the confidential information, trade secrets, or the customer connections. So I would say if you've looked at all of these tests and you think that, yes, definitely we still need the non-compete compete clauses within our covenant, there are two main words of warnings I would give. First of all, arising from the relatively recent case of Ashcourt Rowan Financial Planning and Hall. In this case, the clause prevented the departing employee from working in any role within a competitor. Now, the judge in that case said, well, that's just too wide. This employee in this particular industry could have done an ancillary role that wasn't competitive, for example, compliance or an audit role, which wouldn't have used any of that property of the company and hence get an unfair advantage from that. So when you go back and look at your covenants or when you start to draft them, you'll quite often see that there is, if you're using non-compete clauses, it has wording such as in any capacity. So if you see those words creep in there, think about whether really they are necessary or whether you could end up in a similar scenario to Ashcourt Rowan Financial Planning of being told, well, actually, it's unfair, it's too wide, it goes wider than is reasonably needed to prevent this employee working in any role in a competing organisation. The second point to think about when using it is, well, consider a shorter period for the non-compete clause. So you might have decided that 9 months, for example, is the appropriate time frame for your non-solicitation and for your non-dealing clause. I would say don't automatically say, well, we'll put 9 months in for non-compete too. It is more onerous and a shorter period should be considered. And in fact, if you do put a shorter period in, it will help to demonstrate to a court, if it's ever tested, that you applied your mind to what was reasonable and pitched it at that level. Also, you could think about the shelf life of the confidential information or the contacts that you're trying to protect. That might well have a shorter period, and if so, that's the appropriate one to put in. Okay, moving on to the fourth tip, which is all centred around the fact that reasonableness of a clause is judged at the time of entering the covenant and not in light of the later events. So really this tip is all about advising against drafting in really onerous clauses for anyone you recruit on the basis that, well, by the time we need to rely on them, they're bound to be at that more senior level, which, can be tempting and potentially time-saving. I can see that. The reason I'm advising against it, though, is because the law quite clearly states that if it's too wide when the employee entered the clause, then a later promotion to a more senior level that would have justified it won't make it enforceable. If it was void on entry, it will be void when it comes to be tested later. And if we've got a void covenant like that, they can't be reinvigorated by an acknowledgement of existing terms on promotion. So if you promote somebody and say previous terms apply or previous terms are restated, that's not going to be sufficient. The law tells us that, the case law that's come up before. So an example of that I've put in is the case of Bartholomew's Agri-Food Limited and Thornton, which is a case from last year. And in that case, there was a trainee who joined the organisation, obviously very junior, no customer connections at that stage, but was given really restrictive and really onerous restrictive covenants. So lo and behold, the parties go on, Mr. Thornton elevates through the organisation, and at a later stage, 17 years later, in fact, they try to enforce the covenants at that stage. Of course, they weren't allowed to. It was deemed to be void because at 17 years ago, when this person was a very junior employee, they were too wide, and therefore the employer was left without protection there. So what I've said is to tailor the restrictive covenant as appropriate to the current role. Then if their role changes, they're transferred, they're promoted, etc., then consider at that stage whether the covenants are adequate or appropriate, bearing in mind that well-drafted clauses will have some flexibility. And if not, then seek fresh agreement from the employee and brand new clauses at that stage. Just a word on the practicalities of that. When you're giving new restrictive covenants, you need to think about the consideration that's given for them. Consideration is an important element of a binding contract, and by consideration I mean a benefit to the employee in return for them taking a negative change to their contract, i.e. agreeing to the restrictive covenants. So a separate sum payable for them is a good idea because we can demonstrate that separate consideration for this agreement, or a pay rise, for example, that's just specifically for them. I have seen cases before reported where a pay rise was given across the board to everybody, including those being given new covenants at that stage. And in those scenarios, the employees were able to successfully argue that there was no consideration for this clause. The pay rise across the board was given to all staff. It wasn't tailored specific to them. So if you are tying in a covenant change at an annual pay rise time or an annual refresh of terms, then in the covering letter explaining it all, you need to allocate or refer to a specific amount being allocated, and really allocate a specific separate sum for these new restrictive covenants. Otherwise, the employee may be able to challenge it to say this is void for lack of consideration at a later time. Okay, that takes me on to my last tip, crossing the T's and dotting the I's, boring but essential in contracts, and especially so in restrictive covenants. This is because if a restrictive covenant is signed, if it's signed within an employment contract, there will be a legal presumption that, absent any fraud, it's a binding document. Unfortunately for employees, the fact that it hasn't been read or even understood is not relevant in terms of its legal standing. So always obtain signed agreement from the employee. I've also mentioned that it's ideal to place these restrictive covenants in the employment contract. And that's because sometimes I can see that the employers try to put them in the handbooks to shorten the contracts that are out there. But this gives rise to two potential problems. First of all, is it contractual? More often than not, handbooks are not contractual, or it's unclear what elements of the handbook and policies are contractual and which aren't. We really need it to be certain that it's a contractual obligation on the employee. Secondly, there's the issue as to tailoring. Query whether you can actually practically tailor a restrictive covenant if it's in the handbook. And if it's a stock phrase with stock activities and stock periods of restriction, then it won't have been tailored, and that will be taken into account by the courts in considering reasonableness and whether it's been appropriately tailored in that scenario. So that at least concludes the drafting tips, and so I will pass back to Stephen to talk some more about the enforcement tips.
Thanks very much. As we said earlier, tips number 6 to 10 will cover the practicalities of enforcing a covenant. So this is the situation where, notwithstanding your very careful drafting and tailoring the covenants, as Anita has explained, you found out that your employees have left and you fear that they're going to breach their covenants. You might have been contacted by one of your customers saying, do you know that X, Y, and Z have called me and trying to take my business to their new employer? It might be that one of your remaining employees has tipped you off, and for whatever reason you fear there is a breach and you need to decide what to do next. In putting these tips together, I'm going to share some of my experience of dealing with these sorts of cases for the last 20 years or so, and also drawing out a couple of messages from recent authorities. So tip number 6, and I say of all of mine, this is probably the most important, and there are 4 key reasons for this. You mustn't delay because the court expects you to take prompt action. And the reason for this, when you go to court to enforce a restrictive covenant, typically you'll go to court quite quickly and seek what we call an interim injunction. An interim injunction is a temporary court order that seeks to preserve the status quo until the court has got time to consider the rights and the wrongs of the case in proper detail and come to a reasoned judgment. If you show that there's an arguable case and the balance of convenience would support an injunction being granted as if the covenant were enforceable, then the court will make such an order. And that can be quite a serious imposition on an individual's liberty. In the most extreme example, where you're talking about a non-compete clause, an individual may be prevented from working for a period of time. And because this is such a serious imposition on individuals, the court would decide, well, if you want this, you need to come to court quickly. If you can't be bothered to come to court quickly, you can wait until you have a full trial, and we won't grant an interim injunction in the meantime. The second reason is that litigation isn't always perfect. It can be a disruption. It's a costly process, and you might get the perfect judgment, and the court will give you all of the relief that you were seeking, but you're not able to enforce it because the defendant has gone bust. If you take practical steps in the meantime to stop the damage happening at source, that may be as effective or certainly going hand in hand with taking legal action. The third reason is that no one wants to go to court with these cases. When you're acting for an employer, you want to give a strong presentation of your case and hope that the ex-employee and their new employer will back down and they will honour the covenants. Now, the worst message you can give is by delaying taking any action, because that gives quite a clear hint that you're not committed to issuing legal proceedings if needed, and that will just encourage the ex-employee to ignore the covenants and do what they like. And the fourth reason is that in these sorts of claims in particular, all litigation, but these claims in particular, evidence is very important because you need to prove that the covenant has been breached. And evidence doesn't become easier to get as time goes on. People cover their tracks. So taking quick action to gather evidence is extremely important. Okay, tip number 7. What do you do first? Well, the first thing I'd suggest is take stock. Look at the threat that your business is under as a result of the anticipated or actual breaches of these covenants. What evidence have you got to show that the breaches are happening or are likely to happen? And how strong is your case if it were to be tested in court? And to go through that process, I would suggest putting a team together within your business. And of course, this will depend on the scale of the threat. If your star team is going to a competitor, that's really quite a serious thing that would justify a lot of resource to deal with it. If it's a more junior employee, you're not so bothered about leaving, but less so. And I suggest putting a team together, and that might comprise internal management to deal with the case and all the practicalities that go with it. Probably to take some advice in early stage from the business's lawyers to see how strong the case is, to see whether the covenants are enforceable and what will happen if you're likely to test this in court. Forensic IT from an evidence gathering perspective, and I will say continually why evidence is so important, and forensic IT evidence is typically the best source of evidence in these sorts of cases. And you might also think about things from a PR perspective. If you have that worst case scenario of your star team going to a competitor, that might have created some shockwaves in the market. Your existing customers may be concerned about that, and the business's reputation could suffer, and PR consultants could help with that. I'd also suggest looking at your existing relationships, and the reason for this is if someone goes to a competitor and they're subject to covenants you think they're considering breaching, the first thing they'll be thinking of doing is, who can I bring with me? Can I bring my customers to the new business? I need to build a team there. I'm going to take the best people and bring them with me as well. So taking positive steps to shore up those relationships with your employees, with your suppliers, and with your customers and clients to preempt the attempts at poaching. That can be very important in practice. I mentioned evidence. Now, evidence is important because in these sorts of cases, there's invariably two questions the court has to consider. The first is whether the covenant is enforceable as a matter of law, whether it's reasonable in the circumstances. And the second is, has it been breached? And from the perspective of the ex-employer, you have a lot of suspicion typically, but you might not have hard evidence. And if you present the case to the court and just invite the court to infer that the covenants have been breached, you might find that a bit challenging. In certain circumstances, the court will draw an inference. But if there's a flat denial that the covenants have been breached, I think the court will expect something to show that there is an actual breach. So how do we get that evidence? Now, you might have been tipped off at the outset by your customers, saying that they'd been tapped up by your ex-employee. And occasionally customers will get involved. In my experience, it's relatively rare, and there are two reasons for this. The first is that customers don't like to get involved in what they would see as a private dispute between two businesses. And the second reason is that the claimant, the ex-employer, will be reluctant to put their customer in a difficult position. and want to resolve it with other evidence. So where does that evidence come from? Well, I would suggest immediately talking to your remaining employees who worked with the people who have left, the colleagues, perhaps the PA. They may tell you about some unexplained appointments, some mysterious gaps in a diary in the weeks leading up to the individual's departure. There might be some telephone calls, there might be just some suspicious behaviour that will start putting together a picture of what has gone on. Electronic devices is generally and increasingly so the main area where evidence comes from. And I think most people will know that you can't do anything electronically without leaving a trail. However, it continues to surprise me when I come across these cases, both in the reported authorities and the cases I deal with, that people think it's fine to transport their entire contact list to a private email account and just delete the emails and think that no one will find out, or to transfer their entire email account to a private email account. And again, I think no one will know. But of course, a trail is left, and if you have appropriate forensic IT experts, they can find that. And that's can be very helpful and important evidence, because it's unlikely there was a legitimate reason for doing that other than an intention to breach restrictions. Alongside that, it's worth having a look at internet browsing history. If someone's been looking at sites connected with the business they're going to, at a time when they should have been concentrating on your business, it may suggest they're preparing to breach their covenants and when they shouldn't have done. You might also think of looking at an individual's social media history. Again, I'm surprised how indiscreet individuals can be when they're doing something they really shouldn't be doing. Some other examples on this slide: phone logs and photocopying. It may be that if the individual has an unitemised phone bill, you can see there are lots of phone calls to the new employer they've gone to when they shouldn't have been. It may be they were talking to customers when they shouldn't have been, and that will give an idea that they're preparing to or actually breaching their restrictions. It's possible that someone has an individual account for photocopying, the photocopy in the office. If someone's copied 3,000 documents on their last day, it suggests they did something that they weren't allowed to do. One example I've had in practice about CCTV, one of my clients, a director, left the business, and they knew that some important documents had gone missing, hard copy documents had gone missing from the office. The departing director denied taking them. So my client went and checked the CCTV records from the landlord. Over the weekend, this guy came in empty-handed, left half an hour later carrying 3 jam-packed carrier bags full of lever arch files, which of course complete overwhelming evidence that he'd done it. We confronted him, he had to confess, and he returned the documents. But it's on the front foot in the litigation. Company's house is important because it not only shows if someone has set up a business, a new company to compete, and not only that they've done it, but often more importantly, when they've done it. Did they do so at a time when they should have been concentrating all their efforts on your business? Physical surveillance is sometimes a factor in these cases. And again, this comes back to the question of scale. It's quite an expensive option. If you've got a team of 4 people staking out a property and waiting for hours on end just to see what someone does, it can quite quickly get expensive. But it's in the right circumstances, it's important. I'll just mention something quickly about disclosure in the litigation process. Now, in normal civil litigation, about halfway through the procedure, both parties have to give disclosure. So they hand over all relevant documents to their opponents. It's possible to make applications either pre-action or during the litigation called specific disclosure for documents to be delivered. Pre-action, if you can demonstrate that you have the basis of the case and that early disclosure of the document would help narrow the dispute between the parties, the court might be prepared to order that be handed over. And that can help plug the gap in evidence in the right circumstances. You still need to have a decent case. You can't do it in what we call a fishing expedition, just to see what's out there. Specific disclosure is where during the litigation has already commenced, there's a particular document you think that would be helpful, and again would narrow the dispute between the parties. Normally you'd think about this from the claimant's perspective, trying to prove there's been a breach. The case I have on the slide there of ICAP and BGC is actually the other way around. This is the defendant. This is a case in the finance sector, as many of the reported cases in this field tend to be. Two firms of brokers and always litigating against each other. The party employee denied that he was really as important within his ex-employer in terms of the customer relationships as had been alleged. And he successfully applied for disclosure of ICAP's marketing records to show that other individuals had been marketing to the key customer, and his personal relationship wasn't as important as was alleged. Okay, moving on to tip number 8, adopting realistic strategic goals. And when you come to a case like this, it's helpful at the outset to say, what do I want to get out of this? What will be a good outcome? And that might be just recovering the data that's gone missing. In my simple example of the CCTV, that was sufficient, and that met my client's objective. You might want to enforce the covenants because the covenants have been reasonably drafted in the first place, and they meet a legitimate business interest, and it's important that you have the benefit of those covenants. You might be seeking to send a message either to the new employer saying don't come and steal more of our people, or you might want to deter your remaining employees from jumping ship, making it clear that you will enforce the covenants if it comes to it. It may be that you've suffered financial loss as a result of the covenants being breached, or it may be that the new business is unfairly benefited, has made profit at your expense, and you seek what we call an account of profits. Or you might want to take it one stage further and seek to turn this to your advantage, gain some sort of commercial advantage from the whole situation. And that's why I would suggest be very careful, because it's effectively what happened in the case of Marathon Asset Management and Bridgman. In this case, there was a pretty blatant breach. Mr. Bridgman, the departing employee, had copied 40,000 documents. He did it in a pretty crude fashion. It was discovered fairly quickly, and he was obliged to admit he'd taken them, and he returned the documents. And it was later shown that he'd accessed 52 of those 40,000, but he hadn't actually made any use of them. He hadn't gained any particular benefit from those documents. And had Marathon Asset Management left it there, it would have been a good outcome. They'd have recovered their legal costs, and they would have met most of the objectives on the slide. But they took it a stage further, and they claimed damages, and this was described by the judge as jackpot damages, of £15 million. And they got to that figure by claiming what we lawyers call a notional licence fee, what they would have charged Mr. Bridgman for the permission to use those documents had he asked them to do so. And it came to the court, and the judge said, well, you've got this completely the wrong way round, because you can't take the equivalent price of being able to use those documents, value of using those documents, because he wasn't able to use them. He was caught, and he was stopped before he'd made any use of them. And the judge said, well, you've won, but you're having nominal damages of £2. And because you've wasted everyone's time in getting here, you can pay all of the legal costs of the process after Mr. Bridgman admitted that his wrongdoing. So it turned what should have been a victory really into a defeat. Tip number 9, undertaking or injunction. I mentioned what I mean by injunction. This is the temporary remedy that's supposed to preserve the status quo until you have a full trial. An alternative in this context is an undertaking. An undertaking is a binding promise that is usually made to the court that you will not do a certain thing, or will do a certain thing. Effectively, that you will honour your covenants or an amended form of those. And the advantage is, as I explain in a moment, but in particular, if an undertaking is given but then breached, it sort of fast tracks the litigation. it removes any arguments about whether or not the covenant was enforceable, because that's been admitted. There's a binding promise not to do something, and then you just have to go to court and show that, notwithstanding undertaking, it's been breached. So the factors to bear in mind here: litigation is unfortunately expensive. It can also be a real distraction on your business. And bear in mind, this may be a time when you're dealing with the practical fallout of the breach of covenants, and you want to turn your mind to other things rather than giving instructions to your lawyers and going to court. Also, when you make an application for an injunction, you have to give something called a cross-undertaking in damages. This is because it might be that an interim injunction is granted, but when it comes to a full trial, the court says, well, actually that wasn't breached, or you didn't prove your case, or the covenant wasn't enforceable. We shouldn't have granted the undertaking. And the individual in question may have been kept out of a job for the period of the injunction. Or it might be that their new employer has been wrongly prevented from exploiting a business opportunity and has suffered financially as a result. So the applicant, the claimant, has to give this cross-undertaking in damages, that in that scenario, they will compensate the parties who were subject to an injunction for any losses that they suffered. And that can be significant. The time to consider whether or not to seek an undertakings as opposed to an injunction is a relatively small window. It's typically when you send a letter threatening the claim, and there can be a benefit to both sides. Neither party wants to get wrapped up in litigation, and if parties can agree an undertaking quickly, they can both move on with their business and save costs as a result. An undertaking is not quite as easy as an injunction to enforce. The injunction is a serious court order. On the face of it, has something called a penal notice. So if you breach it, you can potentially be imprisoned. An undertaking, there's some further steps you have to take. You have to show that the undertaking has been breached, and also you have to physically get the case into court. It's not there already. And the final tip: can you share the blame? And here I'm considering, who do you sue? In almost every case, I can't think of a case where it wouldn't happen, you would issue proceedings against the party that is subject to the covenant, the ex-employee. But you might also consider joining to those proceedings their new employer. So how do you do that? Well, you do it by claiming that the new employer has induced a breach of contract. And to do so, there's another stage in the process. So you'd have to show not only that there was an enforceable restrictive covenant, that the covenant has been breached and you suffered loss as a result of that, but also that the new employer induced that breach of contract. And it would be a defence for that new employer to say, well, we just didn't know about it. We employed this person in good faith. They told us they didn't have any restrictions, and we're blameless in this scenario. And if the court accepts that, then a claim against the new employer will fail. An example of this in practice is the case of Tailoring and BGC. It's another broker case. And it was a large team move from Tailoring to BGC. And what happened, BGC was aware that there might be restrictive covenants, and they entered into what they called forward contracts with the employees of Tailoring. Said, come and join us as soon as you can. And they went a stage further than that. And they said, come and join us as soon as you can. And if you get subject to any litigation as a result of leaving early or whatever covenants, we will indemnify you for any loss that you suffer. And that was taking it too far. And they were found guilty of inducing a breach of contract as a result. They were indifferent to the consequences of restrictive covenants, even though they didn't know the exact detail. Why would you want to enforce against the new employer as well as the ex-employee? Well, a couple of reasons for that. There may be a greater chance of enforcing a judgment or enforcing a costs award. It's often difficult to enforce against a private individual because they simply won't have the assets to pay out the award that you get from the court. and the new employer may be more likely to do so. There's also the deterrence point of view here. If you take action against the new employer as well, they will be deterred from stealing more of your either your clients or your employees. However, the process brings greater risk, and again, there are a few reasons for this. Firstly, it may be that the new employer is better able and more willing to fight the case. It won't roll over. And also, because of the cross undertaking and damages that I mentioned, not only will you have to indemnify any losses that the ex-employee suffered, but also any losses suffered by the new employer. So the exposure under the cross undertaking is that much greater. Okay, well, that's the end of my tips.
Okay, so we appreciate that you might have questions arising from the topics and issues that we've covered today, or in fact when you come to draft up your restrictive covenants in future. If so, then please feel free to contact us for a chat. Our contact details are here, though the phone is probably the best kind of use of contact details to get hold of us for an initial conversation. So that concludes our seminar webinar today. We hope it's given you some practical tips on how to make restrictive covenants work in your business, and we'd just like to thank you for joining.